Welcome, everyone. My name is Howard Gould. I am co-chair of the real estate section of the Beverly Hills Bar Association, and I am the chair of today's program on homeowner-contractor disputes and the right to repair. And on some preliminary matters, if you have questions, please try to pose those in the chat. I will try to check that from time to time. You can potentially use Q&A, but easier if I could look in one place for things. Secondly, your MCLE certificates will be emailed out within 24 hours. You should have gotten a link already a little earlier by email for the materials for this program, and they will also be posted. The link will also be posted in the chat, so you can pick up the materials from that location. Next month, we have a program on mediation with a couple of mediation all-stars, Carl West of JAMS, and also a real estate specialist who's going to give you some tips on what to do to get ready for your mediations and what they see actually resolving the mediation disputes. January, we'll probably do a property tax program. We may have a social in December we're still working on. And we are also looking to have a program as soon as we get the okay on a date for the speaker, because the CAR has completely redone their purchase and sale agreement. And so we did a car presentation in July, but we're going to do another one within the next couple months so that people can get updated on the new CAR purchase and sale agreement. I'm very excited today that we have Jason Adams from the Gibbs Giden law firm to be our presenter. Jason and his firm focus on areas of construction law, insurance law and risk management, common interest community law, so that's the HOAs, and business and civil litigation. Jason is also a licensed property and casualty insurance broker and certified construction risk and insurance specialist, that's the CRIS designation. Jason represents developers, investors, lenders, contractors, REITs, design professionals, and other construction professionals in all stages of the construction process. Typical issues he'll deal with include establishing project delivery methods, contract drafting, procurement, and evaluation of the insurance programs for the construction administration, project closeout, delays, insurance claims, and construction disputes. As a licensed insurance broker, Jason provides strategic counsel to clients regarding construction risk management, including contractual risk transfer, the procurement of general liability and property insurance programs, that's the builder's risk insurance. Jason also represents HOAs as general counsel, handles all aspects of association needs, including day-to-day management, governing document drafting and enforcement, contract formation, negotiation, collections, dispute resolution, litigation, and appeals. He's a longtime member of the Community Associations Institute and has served on the CAI Publication Committee and currently sits on their mediation panel. He's a published author, a speaker across the country regarding high-level construction risk management and insurance topics, with a focus on creating new products and program design. Jason's education includes his law degree from Pepperdine in 2001. He attended the Institute of International Comparative Law at the University of San Diego School of Law, and his Bachelor of Science degree is from Central Michigan University. And Jason, thank you for joining us. The floor is yours.
Thanks, Howard. Appreciate that. I didn't realize my bio had gotten that long. Must mean I'm getting old, which is great. So the takeaway from all that, I guess, is I'm a lawyer at Gibbs Giden. We're a 40+ year firm rooted in construction law. And for the past 20 years, I've handled more construction related disputes than I can even remember at this point. So I've represented plaintiffs in large scale fancy single family homes and homeowners associations and massive actions against the developers. I've also represented developers and contractors on the other end that will also deal with this right to repair act. So I've kind of seen this dispute from all angles. And I'm hoping to provide a little kind of practical nuts and bolts type of information beyond what you can get from just Googling these issues or what's contained in the slides. So, thanks for everyone for coming to yet another Zoom presentation. I'll try to get through this and make it a little snappy and interesting so everyone doesn't zone out. Here's what we're going to talk about today. So we're going to go through and discuss kind of an overview of the Right to Repair Act itself. We're going to talk about navigating the process and kind of a timeline of events. And along those lines, I've circulated a couple handouts, which I think should be helpful that we can talk about at the end if there's time. We're going to go through the certain statutes of limitation of repose that apply to these cases. We're going to talk about some issues that are unique to homeowners associations versus your single family home matters. We're going to talk about some insurance implications. As you just heard, I'm kind of an insurance nerd, so that topic alone could take up a whole hour in itself, but I'll give you kind of the highlights. And then again, at the end of it, your head's going to be spinning, so I'll try to boil it down and give some practical considerations and takeaways for anyone kind of dealing with these disputes. So big picture wise, Howard asked me to talk about this stuff and kind of give a big picture overview and kind of tailor it to what we think the Beverly Hills Bar Association crowd might be. And I assume it's probably a lot of either owners or people who represent owners dealing with large single family home projects, or maybe attorneys who represent developers or contractors who are building these projects. All these massive spec homes you see up on the hillside, those are all going to fall under the purview of what we're talking about today. So pay attention that any of those types of projects apply to you. So I'm going to start real big picture and kind of give you an overview of this law and where it came from. In my head, it still seems like a new law, but it came out in January 1st, 2003. So it's coming up on 20 years old now. Basically, back in 2003, construction defect cases were at their height. Every project that got built seemingly was the subject of a construction defect litigation suit. So builders were freaking out. Builders, insurance companies were freaking out. We can't build anymore. The insurance carriers were saying we can't cover these cases, these projects anymore. Insurance premiums are going to skyrocket. Something must be done. So the legislature got together with these different groups, and they had input with different consumer attorneys groups. And what they came up with was this Civil Code Section 895. It was originally called Senate Bill 800. So most people who do this stuff still refer to it as SB800 even today. It's also called the Right to Repair Act. Effective January 1st, 2003, any new residential construction that was signed on, the purchase and sale agreement was signed on or after that date, the act is going to apply. So the goal of the act, again, was to basically give the builders an absolute right to repair projects before owners could sue. We'll talk a little bit later about whether or not the law was successful, but spoiler alert, it's not. It's super confusing. There's still construction defect projects everywhere. Construction insurance is still hard to come by, if not harder to come by, and even more expensive. But we'll get there, and we'll get to the reasons why. Beyond the general gist of why this act came about, the court, if you don't follow the act, the court basically has no jurisdiction to hear your case. So if you try to file a lawsuit without going through these hoops that we're going to talk about, that you have to jump through, the court's going to dismiss your case without prejudice. You can refile later once you go through the different steps of the act. One further point is the act is supposed to be non-adversarial. They make great pains of saying that in the statute, but as you can imagine, these are super adversarial, so they didn't get a base hit with that either. So that's kind of the general overview of the act and why it came about and why we're here. The key points, anyone who's taken a look at this act, and Howard and I were just talking before we got on, he said he took a look at it before and he immediately closed the book. So for all my lawyers on the presentation, you're going to open up your code book and you're going to go to the pertinent civil code section. And the act is just multiple pages, those little thin code book Bible pages of, a 4-point font, single space, boggle your mind type of language. But when you break it down into sections, these are going to be pretty much the general section that the Act is designed to cover. It's going to lay out the actionable defects. They're called functionality standards. We'll get into all of that. It's going to lay out the builder's obligations. We'll talk about that as well. It's going to detail the pre-litigation procedure, which we'll talk about, and which is can be highlighted in the handouts that I prepared. And it's also going to talk about the repair procedure itself, if anyone actually gets that far. So we got a pretty good idea of why the Act came about, what the big picture items are in the statute itself. When the law came about, these are kind of the general issues and the benefits that the law was touted to provide to both sides. Theoretically, these things do exist. Whether or not it actually happens in reality, well, again, we'll talk about. For claimants, it was designed to bring about a prompt resolution of claims. It can do that in certain circumstances that we'll discuss, but as we'll see once we get into the process, even in the best case scenario, if everything goes well, you're still looking at around 300 days from notice to repairs, given the deadlines set forth in the statute. So prompt is questionable. No requirements to show physical injury or damage, so it arguably does that as well. Before the statute was passed, your construction defect claims were governed by a case called HOAS versus Superior Court, which essentially said that you had to have property damage before you could bring a construction defect claim, right? So that was problematic because in certain instances you had, for example, an electrician would install the electrical panel wrong, and everyone knew it was going to catch fire at some point, but because it hadn't caught fire yet, you had no actionable damage. So pursuant to this HOAS case, you were out of luck. So the statute and the drafters implemented language to do away with that unfortunate scenario. Your statutes are going to be told when you're going through the process. So that's a benefit to claimants. You don't have to worry about being out of luck while you're going through this process because you waited too long to file. There's strict liability against the builder if you're able to prove a violation of the statute. Again, we'll talk about that. And the owner can still file a lawsuit even after you go through these processes and repairs are attempted. So those are the benefits to the claimant. Similarly, the builders are going to have some benefits in a perfect world when this the statute actually helps. The builders are given the absolute right to repair, theoretically. Oops, sorry, that advanced. They are given an absolute right to repair. Whether or not that's a realistic right to repair, we'll talk about, but it is there. In certain instances, when the law can be implemented and a resolution can be reached, the builder can avoid lawsuits on the public record or hits on their insurance loss runs. So that's a benefit. A lot of times you have builders doing multiple projects in the same area, so they'd rather not have, immediately public records searches immediately reveal a bunch of different lawsuits on a bunch of different projects. So that is a potential benefit. The statutory scheme does have potential defenses that we'll talk about, which can be potent if you get that far. And they do have shorter statutes of repose for some of the functionality standards that they're violated, as opposed to the 4-year, 10-year statute of repose that applied generally to construction defects before SB800. And we'll talk about those in detail as well. So you have kind of an understanding of the statute itself, why it came about, what the benefits are to both sides. Once you start getting into the nuts and bolts of the statute, the next step is to kind of analyze if it's even going to apply to you and or your project. So your proper parties in terms of a claimant, you're going to be your homeowners, and that's owners of single family homes like the ones in Beverly Hills we talked about previously. It's going to be owners of individual units of attached dwellings. That's basically condominium owners. And it's going to be your homeowners associations themselves. So not just owners of individual owners of homes, but also homeowners associations are going to fall under this act. So your builder, what's a builder? I'm going to conflate that term with developer probably throughout this speech because they're kind of one and the same. This is kind of a wordy splice from the code section, but basically your builder is going to be anyone in the business of selling residential units to the public. So it's going to be your developers. It can get a little nuanced in that general contractors can sometimes be included in this definition if they have some sort of affiliation with the developer. But for the most part, you're talking about owners versus developers. It's not going to include your claims between construction professionals, subcontractor to subcontractor issues, general contractor versus subcontractor, things of that nature. It's generally designed to protect the public. And the thinking is that these construction professionals generally have contractual requirements and they can work out disputes among themselves. So, which parties applies to, and is SB800 going to apply to your project? So generally speaking, SB800 is going to apply to new residential construction, and that's homes or condominiums. And probably even more illustrative than what applies is what it doesn't apply to. So it's not going to apply to your commercial construction, industrial construction, does not apply to condo conversions. It's not going to apply to fit and finish type of warranties, and that gets into a gray area. What's a fit and finish warranty versus what's original construction. So this is when you can start to see even ripples of real world problems developing just when you get into what kind of projects does it even apply to. Even the new residential construction component. Say you have mostly new residential construction, but the foundation's old. Does SB800 apply? Those are kind of hair splitting you start to get into when you start getting into the weeds on the statute. The last thing here that SB800 isn't going to apply to is what's called an enhanced protection agreement, which we'll talk about on the next slide. So we're going to talk about this. They almost never happen. Basically, the bottom line here is that a builder can opt out of SB800 if it puts in its own what they call enhanced protection agreement. Basically, they can substitute the SB800 procedures for their own procedure that's equal to or better than the provisions of SB800. I don't know that I've ever seen it done. I mean, for just a multitude of reasons. First of all, on the front end, the builder would have to pay lawyers to try to dream up some sort of alternate proceeding that's going to either provide the same or better protection than SB800. And if they can do that, if they don't do it perfectly, if it's challenged, then it's just voided and they don't get any of the benefits from either of them. So it's a big expense, it's a lot of risk, likely staring down the barrel of a lawsuit at the end of the day. So I think early on in the early 2000s, after the law was passed, developers would try to get creative and circumvent some of the SB800 requirements, and they paid for it by not having any protections and by dealing with lawsuits instead. Next up, we've got kind of a general understanding of the law. You're checking your boxes here. You know that you're a proper claimant, or an owner or a builder. You know that your project falls under the purview of SB800. The next steps, try to take a look at the statute to see if you're going to have any actionable issues. So this is where the kind of main differentiating factor between SB800 and the prior law. SB800, through a series of what they call functionality standards that are enumerated in the statute itself, they try to lay out every single component of a project. So this one here in particular is just the windows. This is a functionality standard as it pertains to the windows. But there's columns from the statute. It's the windows, it's stucco, HVAC, fire protection, anything you can kind of think of. There's a different standard like this that lays out what the requirement is. If it's not expressly contained in one of these functionality standards in the statute, then there's a catch-all at the end that basically says anything else that causes damage is a functionality standard. So the point of the law is that anything that violates one of these functionality standards is actionable. and there's strict liability to the builder if they're found to violate any of these standards. So again, the point is to circumvent that property damage requirement that was set forth in HOAS and supposedly make it more clear for everyone to know whether or not these standards were violated, and to give a laundry list of all the different issues. So again, once you figure out whether or not you're a proper claimant, whether or not your project falls under SB 800, then this is typically where you go to analyze the different functionality standards next to the issues you're having with your project, and to see if any of them are actionable. So once you get there, the next step in the analysis is to take a look at the statutes of limitation and repose. So we kind of talked about this briefly beforehand. Pre SB 800, there's basically two different statutes of repose that dealt with construction defects. You have your 4-year statute for patent defect, obvious defects you can see just by looking at, and then you had a 10-year statute for latent defects, that's hidden defects that you didn't know about. So SB 800 comes in, and basically for each one of those functionality standards, it lists a different statute of repose, and we'll go through them in the next few slides here. But the statutes, according to SB 800, start running for your single family owner cases. They're going to start running at the close of escrow. For your homeowners association, there's no one close of escrow, right? There's multiple unit owners, and they all have different closes of escrow. So for homeowners associations, these statutes are going to start running either at substantial completion or the date at which the builder relinquishes control of the association, so that the HOA board is in charge of when to bring a claim, and not the original developer. And that's whatever's later of those two. So of course, depending on the facts of your case, that can get a little gray as well, and that's often subject of debate as to when those different statutes started. So in terms of the specific statutes themselves, we'll tick off some of the different areas so you can get an idea of what you're looking at here. The mentality here is that certain things manifest themselves right from the outset, so you should know about them and you should act on them. And if you don't, too bad, basically. So there's a 1-year statute. That's the most onerous one if you're a homeowner, right? It's you have 1 year to deal with stuff like noise issues or irrigation and drainage, stuff like that. It increases from there. You're looking at a 2-year statute.
Jason, excuse me for a second, but what if you have an irrigation, or a drainage issue, but it doesn't really manifest itself? Is there a discovery rule that applies?
Well, that's subject to debate. Basically, you're going to list that in your laundry list in your notice, and the developer is going to come back in its acknowledgement and its defenses and say, no, it's a hard and fast 1-year statute, and you're going to fight about it, and who knows where it's going to land.
The problem, of course, is you could have a year here where we have almost no precipitation, and the next year we have considerable precipitation, and that's when you find out you have a drainage issue that you otherwise never knew about.
Mm-hmm. No, exactly, and that holds true with a lot of these different issues, the water intrusion issues and things of that nature. I mean, the delayed discovery rule that you're talking about is basically going to happen on a case-by-case basis. It typically lands on, if you're the developer, you're going to argue that it's hard and fast. Clever owner counsel will argue that if not here, then it falls arguably under one of the other statutes, right? There's a catch, we'll get to it, but there's a catch-all statute at the end. So you usually can get clever and split hairs and say, okay, if it wasn't strictly drainage, it was, foundation or something else that has a broader statute.
But the drafters of this basically neglected to put in a delay of discovery rule to benefit the homeowner.
Essentially, yes. I mean, it's one of the litany of things that the drafters either forgot to include or didn't include or included poorly. So, like practically speaking, as with most of these cases, the owner piles up every conceivable issue that it has. The developer says there's no issues, or the issues aren't nearly as bad as the homeowner says. You typically get to a mediation at some point with experts on both sides, and it's usually an issue of horse trading regardless of what the actual defects may be. So at the end of the day, it's typically bargaining chips, and usually some compromise is reached. That doesn't necessarily change given SB 800. So 1 year statute, here's a 2 year statute for landscaping, dryer ducts, things of that nature. There's a 4 year statute for plumbing and sewer, electrical systems, cracks in exterior pathways, corrosion steel fences. 5 year statute for paint and stain. And then this is what I referenced previously. There's a 10-year statute for everyone not expressly listed in the statutes we just talked about is going to be 10 years. So most of the time, like you said, Howard, people will try to jam things under this statute in one way or this section in one way or another. If there's potential issues with it applying to a shorter statute of repose.
We did have a question about the overall application of this, because it said before new construction, but what about if you're doing a renovation or even a substantial renovation? Aren't those not covered here?
No, I mean, typically condo conversions, renovations wouldn't be covered. But again, it depends on if what's new versus what's old, right? So if like the example I gave previously, the foundation's the only thing existing. So that's old. Everything else is new. Is that SB 800? Probably, but there's no developed case law on this stuff that splits those hairs that I'm aware of.
So if you take your house down to the studs, which happens in my neighborhood a lot, you don't know whether this applies to your construction dispute or not.
Out of an abundance of caution, if you're mostly new construction, I would proceed as if it does, right? And we'll talk about why that's a good idea in a few minutes, because once you get into this process, everyone usually stipulates around it or someone doesn't follow it and you're in traditional litigation anyway. So you might as well try and check the box so you can proceed and save time and money in the long run.
You have these days ADUs and junior ADUs. So you're doing a garage conversion or you're adding some completely new structure. I guess you're going to probably treat it as if it's covered.
Well, that's, again, you'd have to get into the convoluted language of the statute. And are you signing a purchase and sale agreement, for example, if you're just building an ADU? I'd have to, it would be fact specific, and I'd have to look at the exact language of the statute and split those hairs depending on who I'm representing as lawyers do.
You don't really have a close of escrow that you're going to use as your date. So
that would be the argument. So some of these smaller projects, like the ADUs that you're talking about, that you bring up a good point. That's another whole new wrinkle that, that the statute wasn't necessarily designed to consider. So it's just one more thing that makes it even more difficult to navigate. And we'll talk a little bit about the practical realities of getting into any of these issues in a little bit once we get into the procedure. All right, well, here we are. So, all right, we talked about the big picture law. We talked about who it applies to, what project it applies to. Everyone's kind of scratching their heads at this point. You can kind of guess who it applies to. You've looked at the functionality standards. They don't really cover everything, but you can kind of see where your defects may fall. Okay, you probably have some standard that someone violated. All right. Statutes, we look through those. Maybe some are dinged by certain statutes of repose. Maybe you can argue either way on some other ones, but you're still in the game. It looks like it's time to make a claim, right? So you flip ahead to the other provisions of the SB 800 to look at what you're supposed to do. And this is when it really becomes mind-boggling. And it really becomes apparent that the people who drafted these didn't actually litigate construction disputes and didn't know the realities of how these things play out. So along those lines, this is where all three of my handouts fall under this part of the process because it's the most convoluted. So one of the things I included, and we'll look at these after, is kind of a timeline of events and when things happen. And, if you're going to do repairs with the rough amount of dates after the notice was provided, that you're going to do repairs, so just so you have some concept of, how long this stuff takes. But, it's anyone. It's my best guess at putting some together that it's a cheat sheet that I use, so it's definitely not gospel. A lot of owners understand, and owners council understand, that this procedure is just so convoluted and it's nearly impossible to follow. So what they'll do is they'll draft their notice of claim, which is the first thing you send to the builder, and they'll draft their lawsuit at the same time. So they send the notice of the claim, and as part of that notice of claim, they'll demand a bunch of documents, and that sets off basically two different timelines: document production timeline and notice and inspection and response timeline. And they'll just sit back and wait for the builder to inevitably drop the ball on one of these draconian rules, and they'll go ahead and file their lawsuit the next day. And sometimes the builder is almost relieved that that's what the owner did, because once the lawsuit is filed, you don't have to deal with any of these provisions, and you can tender to your insurance company, and they need their insurance company's participation to even do anything and come up with any kind of viable plan for resolving the dispute. So in practicality, a lot of times you don't even get beyond this original point because lawsuits are filed and someone blows it at this early outset. The two other things, handouts I provided, are notice of claim. So you can see just generally what's usually contained in those and kind of the practical application. And then I also provided just a sample acknowledgement. This is the response you have to provide to the owner's claim within 14 days of receipt. So again, those are typically the documents that are traded at the outset, and that's a lot of times as far as people get, either because one person blows it early in a lawsuit file, or because the parties just look at this, neither side wants to deal with it. And if you have too sophisticated counsel, they'll often just stipulate around the procedures and come up with their own alternate timeline. But for the purposes of today, we're here to talk about SB 800. So I'm going to press forward as if we're going to try to go through the rest of the statute and do what it says, as unlikely as that may be. One more comment with respect to the documents. The original notice often makes a request for documents. They have to be produced in different phases and over different days. There are also issues there, as we'll see from our samples. If one party requests documents, the other party can say, yeah, you have to bring your own independent copy service, and you have to pay for it, and you have to provide, insurance for your copy service. So even the production of documents is problematic for both sides potentially. So just one more wrinkle at the outset that gets people into trouble. So you made the claim, demanded documents, you got a response. Theoretically, the next step after the builder acknowledges the claim is you're going to proceed with inspections. So this is where the statute kind of gets laughable, especially in larger projects, because within 14 days of the builder acknowledging the claim, they're expected to perform an inspection. And not only are they expected to perform an inspection, but they're also expected to notify all responsible parties, subcontractors, insurance representatives, so on and so forth, and give them a chance to attend the initial inspection. So maybe on an owner single family home case with a small builder, is this a realistic timeline? But in any kind of significant project, it's just ridiculous. So, say the owner is a 250 unit HOA complex. They send their demand, the builder responds. At this point in time, the builder doesn't even really know what the defects are. They have some, usually vague allegations from the owner. They have no idea which experts they need because they haven't even inspected yet, so they don't know what the defects are. They don't know which subcontractors to loop in, again, because they have no realistic idea of what the defects are. Yet they're expected to be out on site inspecting in 14 days. And in a case with multiple moving parts, and in the case of a homeowners association where there's unit owners that have to provide access to their units, and you're working with expert schedules and attorney schedules and so on and so forth, 14 days to mobilize this and make it happen in any realistically productive manner. It's just it's a pipe dream. So this is often where the parties will start stipulating to come up with their own timeline and, give whatever 30 days to do the initial inspection. But if you have an owner who's hell-bent on just checking the box so it can sue, this is, where you'll often get pushback, and it's like, no, the code says 14 days, you have to inspect in 14 days. So if you represent builders, what they'll often do is they'll attend the initial inspection, get it scheduled within the 14 days, and then they'll exercise the option provided by the statute. It's referenced down here to conduct a second inspection. You have to let the owner know within 3 days of the first inspection whether you want a second inspection. So in most cases, the builder will demand a second inspection just to give it, you're allowed another 40 days to complete the second inspection. So that'll give a little more breathing room, and it'll allow you to kind of get your feet under you and know what the defects are, know which experts you need, know which subs you may need to loop in. You can kind of ramp up and be more prepared for the second inspection. So there's a way to kind of make this work if everyone's kind of rowing in the same direction. But again, the statute is just written in a manner that it sets everyone up to fail and create conflict from the outset, because no one can realistically meet these deadlines. The owner thinks that they're getting jerked around by the contractor, and why can't you come out and inspect? It creates animosity from the start. So again, if you can stipulate around these stuff, that's typically what people do. So assuming we get this far, you've traded your demand, your acknowledgement, you've conducted a first and second inspection, then the builder can make an offer to repair. This is what the whole statute's about, right? This is what's supposed to happen. But again, the reality differs from what happens in the statute. So if the builder is going to make an offer to repair, they got to make it within 30 days of the completion of the second inspection, right? So it's a pretty short time frame. And if they're going to make an offer, the offer is going to include all their applicable damages, the detailed statement of repair, a time frame to repair, all the documents that were requested, and if they're available, so massive document production. I mean, anyone who does this stuff knows how long that typically takes, let alone 30 days. Deadlines for requesting mediation if you want to, repair contractors documentation, and the last one that we're going to talk about in detail on the second slide, which just creates more of a disaster. You have to advise the homeowner of the right to 3 alternative contractors. So we'll talk about that in a second, but let's back up. So offers to repair are, again, conceptually great. Everyone agrees. Hey, I got it. You made these complaints. I hear you. We're going to agree to repair X, Y, and Z, and everyone goes on their separate ways. But what happens in reality is it's almost impossible for the two sides to agree on a scope of repair. The owner wants, it's Cadillac, every single thing done in grade A form, and they usually arguably request improvements that weren't part of the original scope. And then you have the builder on the other side saying, well, we think we can do this for X, Y, and Z. It's a lot less, it adequately addresses your needs, but it may not be the best possible repair. So in reality, it's nearly impossible to agree on a scope when it comes to these repairs. Another practical consideration is that even if a builder wants to step up and do the right thing, it often doesn't have the money or the wherewithal to do it without the assistance of its insurance company and insurance company funds. And even if it did, even if there was a carrier involved, then making subsequent repairs are often just a nightmare in terms of the realities of the insurance program, which covers these projects. Is there a repair work endorsement? Is conducting repairs going to vitiate any kind of insurance that may be available to the project? So there's all kinds of different considerations that make offering to repair and agreeing on an offer to repair all but impossible to come together on. And then the final thing, which makes offers untenable for builders, is that any offers to repair don't come with a release. So you can do all this work and try to do the right thing and make the offer to repair, and at the end of the day, you don't get a release anyway. So you could make these repairs and still be on the hook and still be staring down the barrel of a lawsuit at the end of the day. So this last bullet, advise homeowner of 3 alternative contractors. Again, as if that repair process and agreeing on a repair wasn't potentially problematic enough, SB800 throws in another curveball and says, hey, owner, we understand that you may not be happy with the original contractor. You know, they're the ones that screwed it up. So you're entitled to 3 alternative contractors to come out and do this work. So the reality is on most construction projects, most of these issues aren't the result of just some totally incompetent general contractor, you know, totally botched the whole project, they're not qualified. I mean, most of the time, the original contractor would be in a perfect position to come out and repair the issues. It knows the project, it knows where the flashing is, you know, that needs to be redone. It's up to speed and can make these repairs in the most efficient and cost-effective manner possible. But with SB800, the owner has the right to demand alternative contractors that the builder has to present to them. So you'll have potentially some new general contractor coming in that doesn't know the project, that has to start from ground zero, and it's just a highly inefficient way to handle any potential repairs. The second major issue with this alternate contractor scenario is it just creates a nightmare in terms of coverage on these projects. So any of these projects are typically going to be covered by, you know, a RAP or an OSIP or a CSIP. And these project-specific insurance policies are underwritten based on the general contractor involved at the time of the project breaks ground. So you can't just come in and willy-nilly start swapping out general contractors and expect the original coverage to apply in the event that these subsequent repairs are inadequate. So there's potential coverage issues, potentially void coverage by swapping out a general contractor to do this work. So,
and Jason, there's no obligation for the insurer to participate in this process, right?
No, I mean, we'll talk about that once we get to the insurance slide. But generally speaking, it's going to depend on your policy. So whether or not an SB800 demand is a coverage trigger is policy specific for the most part. So most policies, I think the trend is that an SB800 notice is going to be a claim or a notice that's going to trigger your coverage under your policy. Most carriers have an incentive to be involved at the outset, so they want to become involved at that point. But there are policies that require an action or a suit to be filed, right? So they're not going to do anything unless and until a complaint is filed or a demand for arbitration, as the case may be. So at this point, your carrier could or could not be involved. And there's also, as we'll talk about, there's issues with SIRs and deductibles. So a lot of times these project-specific policies will have high SIRs where the carrier, again, is not going to do anything until the builder's out of pocket 25, 50 grand, right? So and again, we'll talk about this later, but you want to give notice to your carrier. So hopefully they're involved in some capacity, even if they're not formally defending. But no, if it comes down to selecting an alternative contractor to complete work on these projects, I mean, depending on the carrier, that means, no, we underwrote the original general contractor. We're not letting some new guy come in. If this new guy does the work and screws it up, you know, how are we going to know what the new guys did versus the old guys? You know, they both worked on the roof. Whose fault was it? It just creates all sorts of proof and coverage problems for the unwary. So again, it's just, if you get this far, and even if you have both sides that want to make repairs, it's just the framework of the statute sets it up so it's nearly impossible. So say you get to the point where someone actually makes repairs, or you have a plan that's agreed on, you're gonna go ahead and make repairs. I mean, what's that look like? First of all, the repairs are supposed to be completed by the time specified in any repair plan that's provided. The statute says something about repairs are supposed to be, you're supposed to make a reasonable effort to get them done in 120 days or something like that, which is just, again, ridiculous for anyone who does this stuff and who's been on any kind of significant construction project, especially in light of COVID and, you know, material shortages, labor shortages. And I mean, 120 days is just yet another unrealistic pipe dream that sets the parties up to be adversarial from the start. But okay, that's what everyone's supposed to try to make the repairs. If the repairs are done and the owner still isn't satisfied, then it has to request a mediation before it can file suit. And any subsequent litigation is supposed to be limited to the adequacy of the repairs and any breaches of the standards. So again, even if you get to this point and you have a builder who's trying to do the right thing and make repairs, he's typically not going to be out of the woods, even once you get here. And this is after, you know, significant time expenditures for both sides. Both sides presumably have lawyers at this point. They've hired experts at this point. They've, you know, they're conducting inspections and mediations and doing work. And you're talking about significant outlays of funds, only to potentially end up right back in litigation where you would have been months previously, right? So because of all these issues with potentially conducting repairs, a lot of times what the builder will look to do is pay cash in exchange for a release. So offering cash in exchange for release can be made at any time throughout the pendency of the project. A lot of times builders and or the carriers love to do this because, you know, they both want finality. They don't want to be looking over their shoulders. If they're going to pay money, they want to be done with it. If the owner may prefer this as well, you know, once they get their big chunk of cash, they can fix what they want to fix and maybe not fix other stuff. Maybe some of the stuff in their laundry list of issues aren't as important to them anymore once they get their cash. And they can hire whoever they want to complete the repairs, right? So in an ideal world, cash for repairs is typically a decent way to go. But the problem there too is a practical issue of whether the builder has the resources to pay any kind of significant sum of money if their carrier is not involved, right? So if they have one of those policies where SB800 process doesn't trigger coverage, even if the builder wants to pay, they likely don't want to pay out of pocket. And unless their carrier is going to step up and help fund the settlement, then, you know, this may not be a viable option either. A lot of times when this can be successful is when you have smaller disputes where the owner's demand is somewhere within the amount of the builder's SIR. So it has to spend the money anyway before it can trigger coverage. So I'd rather just give it to the owner and be done with the issue and move on. But again, in any kind of significant disputes, this isn't going to be a viable solution either. So, all right, I think everyone got this point by now, but say you go through all that and say that the builder, or either side, I guess, but typically the builder doesn't follow any one of these steps. It doesn't send the acknowledgement in 14 days. It doesn't, you know, send it by certified mail. It doesn't do the inspection in 14 days. It doesn't produce the documents in 30. It doesn't do any one of these laundry list of things that it's supposed to do. Then the owner can go ahead and file suit. So, you know, the act is pretty strict in that regard, requires strict compliance. And if it's not followed, then you're headed down the lawsuit route anyway. We talked previously about some of the builder's defenses. So SB800 does build in some defenses for the builder. They're going to be, you know, your typical defenses that you see in your typical defect actions for the most part. Unforeseen acts of nature. There's some safe harbor provisions. If your building meets the local building code, stuff like that. Owner's failure to maintain or mitigate its damages, any kind of malfunctions not caused by the builder in certain components. The statutes of limitations and repose that we talked about previously. If there's a release and the owner released it, any kind of from as a result of a cash payment or as a result of some sort of agreement before the SB800 process was initiated, or if the owners made repairs that are successful, the builder can kind of raise all of these different defenses. Who ultimately adjudicates these defenses in the context of the statute is anyone's guess, but I guess you can use these to kind of rebut the claims by the owner.
Jason, where does the homeowner's strict liability come in? I'm not sure I understand that. Supposedly, there's a strict liability standard.
Well, the strict liability standard is basically if the developer has been found to, or the builder has been found to violate any of the functionality standards, they're strictly liable. So there's no proof beyond that. So if you build, whatever, take any one of those standards we looked at previously, if the water intrusion allows water through, then, the builder's strictly liable for that type of issue pursuant to the functionality standards.
Also, somebody wanted to know SIR. I assume that's self-insured retention.
Yeah, exactly. Sorry.
So in an insurance policy, you may have some amount, kind of like a deductible, that you have retained that you're responsible for.
Mm-hmm. Sorry, I'm just assuming all of you are insurance nerds like me. Yeah, that's exactly right. So deductible, similar concept. Deductible is basically your insurance company kind of takes it off the top once it pays out a claim. Your SIR is a self-insured retention, meaning you're essentially insuring yourself up to the amount of the SIR. So if it's $50,000, you basically have to pay $50,000 before your insurance company has to step in. It's almost like a layer of primary insurance that gives the insurance company a little bit of protection before it has to step in. Typically, the higher the SIR, the cheaper the insurance policy. So a lot of bigger companies that have a lot of money and are willing to kind of self-insure basically will opt for super high SIRs. Because
we have about 6 more minutes of our normally allotted time.
Oh, all right. I'll get through it. I did practice this, Howard, and I was under the time, but I did not anticipate questions throughout. So I'll burn through it. We're almost there. Single family homes versus HOAs. We kind of talked about some of this just to further make matters even more convoluted. Homeowners associations are also governed by what's called the Calderon process. So it's similar to SB800 in that it has pre-litigation requirements before you can file a lawsuit as the HOA. It's more geared towards settlement and not necessarily toward the right to repair. The drafters of SB800 knew about Calderon and they still put forth the statute as it is. They had one little carve out that says you don't have to do Calderon basically if the two statutes are substantially similar. So what that means is anyone's guess. They're totally different in terms of timelines and whatever. So again, what most sophisticated counsel do when this issue arises is they come up with some sort of stipulation where they'll either try Calderon first because it's geared towards settlement, and if it doesn't work, then they can go through SB800, or conversely, they'll try to do SB800 first, and if it doesn't work, then they don't have to do all the parts of Calderon because they're substantially similar. This is getting into the weeds. If anyone has any questions about associations, you can reach out to me separately, but there are some other considerations for HOA boards that don't apply to unit owners. Individual unit owners, we talked previously about the trigger for the statutes of repose. Also your governing documents, your CC&Rs and stuff are going to lay out when an HOA can bring a dispute and when they can't, and different maintenance obligations and duties in that regard. So if you're in the HOA world and you want to talk about any of those specifics, just give me a call. We can talk about that given the time crunch. Next up, insurance considerations. We also talked about some of these. We talked about the coverage trigger issue, whether or not your policy is going to consider an SB800 demand to be covered is going to depend on the language. Usually they do. Usually the insurance company wants to get involved. So either way, you should provide notice to the carrier so the carrier is on board and you don't risk waiving coverage down the road. You want to keep the carrier in the loop anyway with respect to any kind of cash offers or repairs you intend to make, because you don't want to do anything that violates any kind of cooperation clauses or jeopardizes the coverage in any respect. Deductible SIR, we already talked about. You also want to look downstream to see if you have to provide notice to any other subcontractors or their carriers. You may have certain indemnity provisions or additional insured provisions in your contract that may give you some protection. So you typically want to provide notice there as well. You can typically do that throughout the time period we talked about originally when you're trying to figure out who else needs to be involved to come to the initial inspections. So again, I could talk about these insurance issues for an hour itself. So if you have any specific questions, it's highly nuanced and fact specific and policy specific, just give me a call.
Jason, is there anything that compels the subcontractors to participate? Because I've seen even just homeowner disputes where you have 3 or 4 or 5 subcontractors who are all implicated in some significant dollar amount issues, and you can't settle anything without having them all involved. But if they're not compelled by the statute to participate, that would seem to kind of bring things to a halt.
Well, that's a good question. So you have to give notice to them, right? So it's in their best interest to participate. They're on notice, but what teeth are there in the statute to make anyone do anything, right? So I don't know beyond providing notice that there's any mechanism to compel them to do anything. I think there are repercussions if they don't participate and they go to litigation. I think they waive their rights to complain, and then they can be looped in just like any other case. But in terms of making them do anything aside from giving them notice, I don't think there's any way you can force them to participate.
So if you have a lot of significant subcontractor issues, or even 1 or 2, you may want to just stipulate to go right to court so you can get all the parties in one place.
Yeah, I mean, typically, and that again, you got to kind of, you just pray in these cases, you get someone on the other side who knows what they're doing and who understands risk transfer, who understands insurance, who understands the need to get the subs involved. I mean, best case scenario, you just say, forget SB800, let's either table it or stipulate around it and try to come up with our own alternate procedure to try to get this done, and you go about it that way, and that gets all the right parties to the table and hopefully gives you the best chance of success. Otherwise, you're looking at a traditional kind of maybe pay and chase, like they did in the old days, but it's just it's much better to get everyone involved from the outset.
One more question, which is, where do you see a situation where it's not clear whether you have the builder or developer involved so that this applies? Somebody was saying if you don't have a builder or a developer, this isn't involved, but where do you see that coming up?
I can't see how you would have anyone building any new construction who wouldn't fall under the definition of a builder. I mean, if not, if you really didn't, and it was only general contractor and below, I guess, then I guess you just go directly and circumvent the statute. But by definition, whoever constructed the project and who was in charge of it would fall under that original definition we talked about, someone in the business of constructing and selling residential homes or whatever it is. I've never seen that. That'd be interesting.
What if I own the lot and I just retain the general contractor?
It's interesting, I guess. Are you in the business? I mean, and you would have to bring your own action against the GC, you mean?
Yes, exactly.
I would say that you're excused from the statute because you're not in the business of selling residential projects, and you hired the GC who also is not. So I think that'd be more of a direct action type scenario. But again, I mean, you see this, and it almost doesn't hurt. If you're ever in doubt, it almost doesn't hurt to send the notice, because you're going to eventually get to file a lawsuit anyway. So that's kind of the benefit risk analysis you have to go through, right? Does it make more sense just to do it and inevitably fail and proceed to a lawsuit anyway, or to just skip it and risk your case being dismissed for lack of jurisdiction? So there's only a couple more slides here if you wanted me to just burn through them, given the time constraint. Here we are. Conclusion. So did the law work? I think we touched on this at the outset. No, I don't think so. Construction defect litigation is still everywhere. From the insurance end of it, coverage is even harder to obtain. It's more expensive. It's more restrictive. I don't think it did anything to the construction defect landscape aside from put up additional hurdles and cost everyone more money. I mean, that kind of dovetails into the takeaways and practical considerations. It can work in certain small disputes. If you're an owner, it doesn't hurt to send the notice. It typically gets someone's attention, if nothing else, and it starts the process. If you have small issues and you're reasonable in terms of what you'll take, then you could conceivably get something done. Similarly, from the builder end, if you want to get out in front of a dispute and quash it before it spirals and before you have a lawsuit on your public record and some hits on your insurance loss runs, it may be a good way to do that. But for any kind of big picture, large scale construction disputes, it's just almost impossible to navigate and with any type of success. So just one kind of closing comment here. So, I've been practicing this speech, and I'm thinking to myself, is it just me that this doesn't work for? Maybe I'm in my own bubble and I'm crazy and this is super successful for everyone else, right? So, polling other lawyers and just talking to people as I'm preparing for this. No one I've talked to has any success. I actually reached out to an expert that we used on some of these cases for over the years. And he's got, old school, 40 years in the business. I was like, hey, before I give this presentation tomorrow, if you had any success with SB800 whatsoever? And his response was, no. Out of scores of SB800 cases I've participated in, the defendants have never been able to fill their requirements to bring complete resolution to the SB800 statute. Thus, almost all these CD disputes ended up in conventional litigation. On occasion, a plaintiff or two have dropped out of the dispute without gaining a resolution due to attrition. So that's just another third party who's dealt with thousands of these things that has had zero success with the statute.
We're a few minutes over, but could you take just a minute or two and just show people your handouts and mention that when those are used?
Okay, yeah, no problem. Oh, here. Yeah, if you want to find me, there's my email. Unfortunately, I'm on social media because my marketing lady made me be on social media. So if you want to see my kids and stuff, you can go to Instagram. That has nothing to do with construction. So I'm going to stop share here and burn through these handouts real quick. So you should all have these. If not, shoot me an email. Okay. So this is, a stab at outlining all these different deadlines, anytime before the applicable statutes of repose, you have to file your claim. That starts the process. That's day one. Within 14 days, you have to acknowledge the claim. We talked about the acknowledgement. That's day 14. Before the inspection, you have to do all this stuff. 14 days after the builder acknowledges notice, you have to complete the initial inspection and you have to do this stuff. And you're at day roughly 28 or so. After the first inspection, you have to give notice to the second inspection, blah, 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 blah. So all the way down, it kind of goes through the process, all those things we talked about. It kind of contextualizes things, and it gives you just a rough ballpark idea of where you're going to be in terms of days when you get to these certain areas, if you can even get through the myriad of requirements. So, it's supposed to provide quick resolution of these disputes. I mean, you see here you're at, you're talking about completing repairs and mediation, you're 183 days in, So this is a good kind of cheat sheet. Again, it's not gospel. You can modify it yourself, but it'll give you some idea if you're hit with one of these things, where to look out of the gate. Like, oh God, I have 14 days to respond. What do I do? This should help.
Can we go on to your next letter?
Yep. So again, I can burn through these. This is just a sample notice. The first thing everyone sends. We don't need to belabor this. It kind of is what it is. Hits the highlights, preliminary list of defects. It's just a fictional HOA to a fictional builder on a fictional project. Kind of just the nuts and bolts. What could be in a notice. And then here's a sample kind of acknowledgement. This looks like just an owner issue. Again, some of the issues that arise, you can kind of see how all that complex, convoluted stuff we talked about kind of boils down into your initial response when you get hit with one of these things. So they're kind of practical things you can use as examples. And again, once you're at this point in the game, Hopefully you have a sophisticated counsel on the other side and you say, let's forget SB800 and you come up with your own alternate timeline. But if not, those should at least get you started till you get your feet under you.
And then I think there was a notice of commencement of legal proceedings that was your last document.
Yeah, that was the first thing we looked at.
Okay, great.
Yep.
Well, thank you very, very much, Jason, for that overview and all the detail you were able to fit in an hour for us. Very interesting statute that we all obviously want to avoid if we can.
Yeah, there's one takeaway.
Procedure. But we appreciate you coming, and thank you to our audience for all tuning in today, and we'll look forward to hopefully seeing you again next month. And we'll get Jason back on some other interesting topic in the future. Thank you very much.
Thanks, everyone.